University, and I'm delighted to be here. Welcome to today's session on risk assessment, dangerousness, and AI. As artificial intelligence continues to evolve, its integration into decision-making processes, particularly in risk assessment, has raised critical questions about safety, accountability, and potential for harm. In fields like criminal justice, healthcare, cybersecurity, AI is being used to predict risks and assess dangerousness, yet the reliability and ethical implications of these assessments remain a key concern. Today, we're honored to have with us Mr. Ankit Kaushik. Mr. Ankit Kaushik is a graduate of National Law University, Jodhpur, with an LLM from NLU Delhi. He specializes in criminal and constitutional law. He has served as an assistant professor at Rajiv Gandhi National University of Law, Punjab, and as a research associate on the Indian Penal Code Reform Committee by the Ministry of Home Affairs. Mr. Kaushik has conducted major research projects on crime against women and the National and the Juvenile Justice Act. He is the executive director of the Journal for Victimology and Victim Justice. Additionally, he has collaborated with the National Investigation Agency and BPRD on legal frameworks for radicalization and de-radicalization, earning a commendation from BPRD for his research on community policing and radicalization mitigation. I look forward to his valuable insights on this topic. Over to you, sir. Thank you for joining us.
Okay, a very good evening to all, and thank you, Aditi, for that very kind introduction. And at the outset, I would also like to thank Dr. Navtika Nautiyal at NFSU and Dr. Kalpeshwar Gupta at Law Teachers India and the head of Pro Bono India for inviting me to speak on this very pertinent topic on risk assessment, dangerousness, and measure of invited speakers, as well as the topics that they have taken up for discussion so far. And all the topics, they're not only relevant, but they're also, they represent the very cutting edge of the discourse on artificial intelligence and the law in terms of the interface between the two. They also represent the discourse on the regulation of artificial intelligence in international humanitarian law, artificial intelligence in facial recognition technologies, and so on. Today's lecture, however, will differ from all of these preceding lectures in a very important regard. For this lecture, we will be examining the interface between criminal justice, criminal law, and artificial intelligence with a very specific focus on its place in the criminal law theory. Specifically, we'll be looking at how the pre-conviction and post-conviction decisions by the courts, prison authorities, as well as the state, um, you know, they are today coming to be governed by the paradigms of risk assessment, dangerousness, and artificial intelligence is making a foray into all of these realms as well. We'll be looking at what are the key challenges that we are facing today and that we are likely to face in the coming days. And the lecture will also focus very specifically on the need for a normative approach. And in particular, we'll be looking at three scholars, Anthony Duff, Christopher Slobodin, as well as Andrew Ashworth and Lucia Zedner, for the purpose. Ultimately, we'll be looking at key conclusions and key takeaways. And throughout this lecture, I'll be arguing that, focusing on a very normative discourse on criminal law can help us understand risk assessment, can help us understand dangerousness, and therefore, in turn, can help us regulate, not only regulate, but also develop artificial intelligence technologies, which are much suited to the needs of the criminal justice system at large. In order to understand all of this, however, we need to place into perspectives the needs and requirements of criminal justice and criminal law that underscore such an examination. Uh, this is a need that scholars today term as the that even though criminal law has been around for centuries, we still have not been able to resolve even the most fundamental issues that pertain to the very basics of criminal law itself. And one of these sites of contradiction is the tussle between the ex ante and the ex post perspectives in criminal law, right? So, from a functional point of view, criminal law is very widely accepted to perform both an ex ante as well as an ex post function. The ex ante perspective refers to the idea that the criminal law performs a function before the commission of a crime itself, whereas the ex post and perspective, it focuses on the role of the criminal law after the commission of the crime. There is, however, a very marked difference between the engagement of the academic discourse with both of these functions. And the fact is that most of our scholarship in criminal law today, it lies on this idea of response once that harm has been committed. A vast majority of the debate of criminal law theory and doctrine so far has been directed towards this this ex post function of criminal law, which can be exemplified in our treatment of the most pressing debates in criminal law today, the most hot and debated issues, the most deliberated issues in criminal law today, such as that of, for example, honor killing or mob lynching, hate speech, hate crimes, criminalization of homosexuality, prostitution, adultery. So far, all of these debates, the way scholarship has treated them, they have looked at it only from an ex post lens, and they have not stopped to wonder as to whether criminal law has some implications on these debates in terms of its ex ante perspective as well. And in this sense, it is very trite to say that the ex ante debates of criminal law have hardly been the focal point of our scholarship. All debates on criminalization, however, would be incomplete without a very nuanced understanding of the preventive rationales that underscore these debates. Any law which carries with it the threat of criminal sanctions is also bound to be premised on the understanding that the law will deter individuals from engaging in that criminalized conduct. So it has been very widely accepted that criminalization and criminal law must reduce the incidences of crime in the society itself. And a preventive rationale, therefore, is inbuilt into the very idea of criminal law. It's inbuilt into all debates on criminalization, whether we want to focus on it or not, right? So there is a very increasing realization today amongst law and policy makers that the point of intervention of criminal laws must be before the harm actually occurs. It must be prior to that harm, right? And the same has prompted scholars such as Andrew Ashworth, Lucia Zedner, Henry Carvalho to identify the same as the preventive turn in criminal law, right? So, in her book titled Fixing the Future, The Preemptive Turn in Criminal Justice, Lucia Zedner, she states that the rise in risk has a marked temporal shift towards calculation, anticipation, and preemption of harm using both the preventive as well as incapacitative measures. The same can also be gauged from the use of very sophisticated actuarial tools in determining dangerousness as well as risk assessment, and increased usages of surveillance and intelligence gathering. So Zedner, she proffers that whatever traditional reactive strategies that you have with respect to crime control, today all of these strategies are coming to be supplanted by preventive measures to ensure and maximize this concept of security, right? State security, national security. And she argues that initiatives such as surveillance, situational crime prevention, community safety initiatives, risk assessment, actuarial profiling, offender registries, preventive orders, all of these are encouraging a shift today from a post-crime society to a pre-crime society. And Zedner notes that this shift from a post-crime paradigm to a pre-crime one can be attributed to a very consequentialist logic of security. Consequentialist because they're only looking to secure the greatest happiness for the greatest number of people, right? She proffers that such a paradigm of security It allows for the warrant of intervention and curtailment of individual liberty at increasingly prior points of time against as yet unspecified or remote harms. So, what we're looking at today is that the state is not waiting anymore for the harms to occur. The state is seeking to intervene very actively, uh, through a mix of measures that I'll be elaborating upon very, shortly. Through these measures, the state seeks to intervene at times prior to the harm itself. Nevertheless, the idea that the state wants to increasingly impose very intrusive measures in the name of security, this idea seems to present only one side of the picture. The fact is that preventive justice is not just an agenda of the governments. It's not just an agenda of political parties in the name of political, mileage, so to speak. But this is also an agenda of the people themselves. People believe that their governments are not tough on crime, right? And this has led to the creation of very rhetorical slogans such as the war on crime, such as the war on terrorism, such as the war on drugs itself. And citizens claim that they have a right to be protected by a very efficient criminal law, and that this right to be protected is very effectively preventative in nature. It is essentially the duty of a state to guarantee security and safety to all of its citizens as well. At the same time, we have Henry Carvalho, who, in his very seminal work titled "The Preventive Tone in Criminal Law," he proffers that the world today it's in a very constant state of flux. There's a lot of uncertainty that's involved in the world today, generally, right? There's a lot of insecurity. There's a lot of anxieties that our state and we today have to battle with. According to him, according to Henrique, uh, this kind of a state of anxiety, this kind of a state of insecurity, it has very great implications for criminal law itself. And that the developments, they're particularly worrying for the liberal project in law and justice. The shift in the focus of the lawmakers to the preventative domain has resulted in the extension of the boundaries of criminal law itself through multiplication of offenses and through the expansion of state powers in terms of surveillance and crime control as well. And there are a lot of ways in which this actually happens, right? This can be achieved very substantive, for example, by defining very substantively offenses in an inchoate mode, offenses such as attempt, offenses such as abetment, conspiracy. But this can also happen through defining offenses in a pre-inchoate mode, right? So pre-inchoate offenses are those offenses where not only is the harm not done, but we are one step removed from even inchoate offenses themselves. For example, offenses relating to membership, right? If I become a member of a proscribed organization, or if I am still an active member of a proscribed organization, the actual harm is very far away from my actions alone, right? So my only action is that I'm a member of an unlawful association, right? I'm a member of an unlawful organization. And I might not be involved in any kind of activity with respect to that unlawful association, unlawful organization, but my association, my membership with that organization itself is sufficient warrant to invoke this pre-inchoate liability against me. But this also happens through procedural measures, right? For example, the police have the power to preventively arrest a person, not just under special laws such as the National Security Act or the Public Safety Act, but the police also has the powers to arrest a person under the Bharatiya Nagrik Suraksha Samhita as well. And this arrest is grounded in preventive rationales. It doesn't have to be reactive to a crime very specifically. And of course, today we see that risk assessment and dangerousness, they are emerging as very paradigmatic areas in the discourse on preventive criminal laws, preventive criminalization in and of itself, right? Which brings us to the next segment of our presentation today, which is on risk assessment and dangerousness, right? Just a second. So, the thing is that speaking in a very broad sense, the risk assessment is something that is conducted in almost every aspect of our daily lives, right? At its simplest level, we conduct risk assessment when we are trying to, for example, overtake a car while driving. So, most of it happens unconsciously. But whenever we overtake a car, there are so many calculations that are happening in our head. We calculate the speed of our car versus the speed of the car in front of us. We calculate the what is the width of the road in front of us. We calculate if we will be, encountering any obstacles while we are in the process of overtaking in and of itself. And all of this is essentially this idea of risk assessment, right? So we are taking into account all of the risks that can, happen or that can occur, why or all of these eventualities that can happen while we are overtaking a car when driving. But very specifically, this idea of risk assessment also finds an application in businesses, right? For example, you have insurance companies, and whenever an insurance company offers you health insurance, it conducts a risk assessment to determine what should be your premium, what is the premium that you have to pay to that insurance company. So what it's taking into account there is what is your age, for example. So your premiums are bound to increase as as your age itself increases. Or what is your prior history of hospitalization? What is your prior medical record? Do you have any chronic diseases, such as bronchitis, right, or asthma? And or for example, do you what are your habits? Do you smoke? Do you drink? And all of these will go into their calculation in terms of deciding what your premium should be, because all of these directly contribute to your risk of hospitalization in and of itself, right? So these are very broad areas. These are where this idea of risk assessment finds an application. But risk assessment is also coming to be very selectively applied in criminal law and criminal justice as well. And the functionaries of our criminal justice system, believe it or not, they have to very routinely make such calculations as well, where they have to calculate what is the dangerousness of a person in terms of their likelihood to cause some injury, to cause some pain, or to cause some harm at very specific decision making points in the criminal justice process. So this calculation of risk assessment, it happens primarily at very three distinct points. The first is at the pre-conviction stage, right? Where decisions, for example, with respect to grant of bail have to be made, right? So I've listed out this example in front of you. We're talking about Prashant Kumar Sarkar versus Ashish Chatterjee, where the Supreme Court noted that the factors to be taken into consideration by the courts at the time of the grant of bail must also include the danger of the accused absconding, what is the likelihood of the offense being repeated, is there a reasonable apprehension of witnesses being influenced by the accused, and in general, what is the risk of the very or what is the danger of the justice itself being thwarted through the grant of this bail. This also happens at the stage of sentencing, where the length of the sentence, or even the determination of punishment itself, like what kind of punishment has to be granted. Should we be awarding the death penalty? Should we be giving them life imprisonment? Or should we be giving them 10 years imprisonment, 7 years imprisonment, depending on the kind of offense? In Bachchan Singh versus State of Punjab, for example, the Supreme Court endorsed, in preventive terms, they endorsed two standards which count as mitigating factors in the grant of death penalty. The first was the probability that the accused would not commit criminal acts of violence as would constitute a continuing threat to the society. And second was the probability that the accused can be reformed and can be rehabilitated. Then, of course, the third point of intervention is at a post-conviction stage, where decisions regarding parole, probation, and furlough to the prisoners have to be made, or even with respect to premature release. Such a decision has to be made. Premature release in the sense of remission or maybe even commutation of a sentence. So, in the case of Lakshman Naksar versus Union of India, the Supreme Court observed that the question whether there was a chance of a crime being repeated in the future, as well as whether the convict has lost the potentiality to commit a crime, these form very important factors in determining whether premature release can be granted to a convict. In India, we find that though this idea of risk assessment and dangerousness, it has been institutionalized by judicial decisions and through law and policy as well. Uh, the law and policy makers themselves are yet to adopt any objective criteria with respect to the same. So, for example, we are yet to develop any kind of a sentencing policy with respect to what the aggravating or the mitigating factors should be in normal cases, in cases of imprisonment, right? Most of the sentencing policies that have been developed by even the judicial decisions, they pertain mostly to death penalty in and of itself. So we don't have any objective criteria with respect to sentencing. We don't have an objective criteria with respect to the grant of remission by state governments. We don't have an objective criteria with respect to the grant of bail by all judges, right? So, this decision of whether a bail has to be granted by a judge, this comes to be continually challenged before appellate courts, who, the lawyers go to the appellate courts and they say that wherever there has been a denial of bail, that the courts do not take into account all the factors that they should have in such a case, right? Um, at a global level, however, we find that the violent risk assessment tools are, they're very increasingly coming to be used, not just within the domains of criminal justice, but also within the domains of forensic psychiatry. Uh, One study by Douglas et al., found that there are over 200 structured tools that are available for this purpose. And these tools have been very extensively utilized in jurisdictions such as Canada, jurisdictions such as New Zealand, United Kingdom, and United States of America. So I've given some examples, and these are on your screen right now as well. One of them pertains to correctional offender management profiling for alternative sanctions, or COMPAS, which has been developed by North Point. And believe it or not, this particular software has been used to assess over 1 million individuals in the United States criminal justice system alone since it was developed in 1998. And this particular software was developed in order to predict a person's risk of reoffending and recidivism. uh, if you take a look at its methodology, what are the data sources that it relies on? So the compass itself relies on a large range of data that is collected from the individual himself. But it includes the individual's criminal history, their past offenses, their past arrests, and any other relevant information within the criminal justice system. In terms of its algorithm, if you take a you know if you try to understand the underlying algorithm of Compass, you'll find that it uses certain statistical models in order to analyze what kind of an input has been, what kind of input data goes into this, and in order to generate these risk scores. And what Compass does is to look at historical data in the criminal justice system to predict the rate of recidivism, which is based on certain patterns that have been observed in the past offenses, in the past offenders themselves, right? So basically, what you're doing here is like you're deciding and looking at which particular persons, what are the characteristic traits of persons who have reoffended in the past, and therefore are at a greater risk of recidivism. And then what Compass does is to compare the individual traits of these individual of the current impugned persons with that past data in order to see what is this current person's rate of or risk of recidivism or reoffending itself. A second risk assessment tool is that of PSA, the Public Safety Assessment, and this has been developed by Arnold Ventures. The PSA evaluates the likelihood of pre-trial offending and a failure to appear in court. And it provides the risk scores based on 9 factors, such as what is the age of the accused, what is the current offense that they have been indicted for, what is the pending charge at the time of arrest, are there any prior misdemeanor activities, are there any prior felony convictions, are there any prior violent convictions, are there is there a prior failure to appear before a court within 2 years, or is there a prior failure to appear before the court something more than 2 years ago, right? So it takes into account all of these particular factors in order to come to the conclusion as to what is the rate of default, that, or what is the risk of default that this person has in terms of appearing before a court if a bail is granted to this person. And the thing is that this application of algorithms in order to understand a person's risk of recidivism, their risk of reoffending, or their risk of absconding justice itself. There is a term that has been coined for it, and this is called actuarial justice itself. This is a term that was first coined by Malcolm Feely and Jonathan Simon. And actuarial calculations in the criminal justice system, they deal with the intentional commission of offenses that, and I quote, result from multiple variables that influence the thinking and the actions of individuals themselves. Having this understanding of risk to assessment tools itself, we can now move on to what are the advantages and the disadvantages that these risk assessment tools themselves have, right? There are, of course, benefits to having an algorithm and a tool-based calculation of risk and dangerousness and risk assessment and dangerousness. Number one is that it introduces objectivity in decision making. This kind of objectivity, it works at two levels. Firstly, that it is not humanly possible that even if all the aggravating and mitigating factors remain the same, all the functionaries of the criminal justice system will come to the same conclusion with respect to the decision on incarceration or release. While one judge may decide to grant bail on a certain set of facts, another judge may decide not to grant bail on a similar set of facts. Secondly, even if the decision-making functionary remains the same, the decisions, even on a similar set of facts, they may change from one day to the next, right? Depending upon the thought process or the mood of the decision maker. So what risk assessment tools do is to remove this kind of a subjectivity from the system. They streamline this entire process. They make this entire process rather objective in nature, so that we know that the outcomes themselves are fair in that sense, right? And this also brings us to the aspect of consistency, or an advantage of consistency. So given the same set of parameters, an algorithm or a structured tool, it will always come to the same conclusion. But that's not the case wherever human intervention is involved, right? Because a lot depends on a person's mood, a lot depends on a person's experience over a period of time, that might bias or that might prejudice that person against giving the same decision that he would have given earlier, right? Um, another advantage itself is that an algorithm-based risk tool also helps bring about efficiency, in as much as they require much less manpower to execute a decision-making process. So we are all well aware that in India, our criminal justice system suffers from a very severe dearth of manpower, with vacancies being abound in every service, right? You can take a look at police service, judicial service, or prison services. There is a very severe lack of manpower, and all of these with respect to all of these functionaries of the criminal justice system. So risk assessment tools can actually help us reduce the inefficiency or in the system by by replacing the need to have more manpower within the system, right? Um, at the same time, there are very major issues in the application of algorithmic risk assessment tools as well. Number one is that these algorithms, they have a tendency to increase penalties for whatever offenses are most prevalent in general, right? For example, if there are a lot of offenses against property being committed in the same jurisdiction, or there are a lot of offenses against human body being committed in the same jurisdiction, or there are a lot of drug related offenses being committed in the same jurisdiction, then there's a good chance that the algorithm, based on its calculations, it's going to increase the penalty, or the penalty that is recommended for these kinds of offenses, regardless of what was the severity of these offenses itself. Another problem is with respect to the biasness and unfairness that that these algorithms bring in the system. So many of these risk assessment tools, they've been criticized for perpetuating existing biases. They inadvertently end up reinforcing racial, socioeconomic, gender-based systemic biases. And the tool might end up, on the basis of these biases, the tool might end up predicting a higher rate of risk for certain demographics that can be found in the society. and it's not necessary that these rates of predictions will be accurate, right? For example, I gave you the example of Compass in the previous slide, right? That particular software has been criticized very severely for on the ground that that black defendants, persons who were who belong to a black ancestry, those defendants who did not reoffend were very incorrectly predicted by the algorithm to have the potential of reoffending at a rate of 44.9%, which is nearly twice that of white, which was at 23.5%. And at the same time, the white defendants who actually did reoffend, they were incorrectly predicted as not being capable of reoffending at a rate of 47.7%, which was twice as high as their black counterparts at 28%, right? So we see that there are biases that can stem into the system, because remember what this particular algorithm did was to train it on past or historical data, right? So it can't predict trends in the future. Rather, what ends up happening is that it ends up reproducing the biases and the prejudices and the stereotypes that were present in the earlier data itself, right? So it basically inputs as garbage in and garbage out, right? And there are, of course, other problems with using objective risk assessment tools, such as transparency and accountability, where the users cannot understand how that algorithm works, and they may end up relying on the same blindly, and that the same will lead to unjust outcomes, or that it leads to ethical issues as well. Where we are punishing individuals and taking away their right to life and personal liberty, their right to movement, their right to freedom of speech and expression, on the basis of their potential to commit a future offense, rather than an actual commission of offense in and of itself, right? And the thing is that, even though Compass and PR, the other tool that I had mentioned, or all of these tools, they are not actually artificially intelligent in nature. They're based on an algorithm, which basically which produces a statistical model that gives us a risk of recidivism itself. The problems that the use of artificial intelligence can actually bring in with respect to these application of these risk assessment tools, right? That also needs to be studied at this point of time. And the thing is that these problems that I've highlighted, they have the potential to be further exacerbated with the advent of artificial intelligence itself. Because artificial intelligence can then inherit and then amplify the same problems, for example, such as biases, which are present in the data on which it has been trained, much like Compass, if such training is done using a historical data. It can also lead to an infringement of the presumption of innocence, in as much as an artificially intelligent tool may rely not on the offender's risk of recidivism alone, but rather on the data relating to the actions of individuals who are very similarly placed to that individual itself. So what we are judging here is how likely people in general are likely to reoffend, right? So we are not looking at that particular individual's risk of reoffending, therefore it violates the presumption of innocence in and of itself. And of course, that lack of transparency and accountability that we were talking about earlier, that also comes to be further exacerbated, because if understanding how a particular algorithm work is considered to be a tall order, then understanding how an AI model works is basically termed in the academic discourse as an informational black box. Because unraveling the complex deep learning networks is nearly impossible, in as much as there is a grave lack of interpretability with respect to that, with respect to how the AI went about conducting that risk assessment, what all data did it take into account with respect to that. So understanding how AI comes to a decision is significantly more complicated than understanding how an algorithm or how a person came to that decision. thereby making thereby making that that much difficult to challenge whatever outcomes are created, right? Um, Now, highlighting all of these advantages and disadvantages, as well as what are the benefits of risk assessment tools, this highlights the need for us to bring in some semblance of objectivity into the system, right? So the thing is that the only way in which we can actually ensure just outcomes in terms of risk assessment and the use of technology is to aid the same by at the time of its development itself, right? If we develop certain normative guiding principles based on a very foundational understanding of what is risk assessment and what is dangerousness, and also what is preventive criminal law, then we can actually guide the development of AI models and guide the development of technology without replicating those biases by at the same time introducing transparency and accountability into the system, at the same time maintaining a presumption of innocence with respect to these algorithms, right? So these normative principles, therefore, can act as a check on the use of algorithms in such decisions making, but at the same time, it can also act effectively guide and guide and aid the development of future AI models to aid in such decision making. The fact, however, is that the state of legal scholarship on this question of risk assessment and dangerousness, it is yet to fully mature. We are yet to develop such a concrete normative framework that governs the use of risk assessment in criminal justice. Although scholars are, certainly working in this direction. Three scholars in particular, they deserve a very specific mention in this context. The first work is that by R.A. Duff, and this is from his book chapter titled "Dangerousness and Citizenship" from Andrew Ashworth's Fundamental of Sentencing Theory. In this work, R.A. Duff, he conceived this idea of special selective detention to incapacitate dangerous offenders after they have served their time, their prison term for that offense, right? So what we're deciding here is that once a prisoner has served his entire sentence for entire period for which he had been sentenced, and we are at that stage of determining is he ready now to be released into the society. So that's the stage at which R.A. Duff conceived this idea of a special selective detention. And he says that special selective detention is special in that it involves longer periods of imprisonment than those to which the offenders would normally be liable. It is selective in that it is focused selectively on offenders who are thought to be particularly likely to commit further serious crimes if released at the end of a normal prison term. So Duff basically determined that a criminal behavior is essentially a manifestation of a criminal's dangerous character in and of itself. And Duff says, and the quote is on your screen, that the connection between the character traits which make a person criminally dangerous and the criminal conduct which would manifest those character traits is logical. It is not contingent. Um, to have those character traits is to be disposed to behave in those criminal ways in situations of the appropriate kind. To say that the criminal conduct manifests those characters is to say that the conduct constitutes the public actualization of those traits in and of itself. So he's tried to define this idea of what is dangerousness, right? And if you have if you have a comprehensive idea of how this concept of dangerousness comes about to be, and how should you actually be determining risk assessment based on this concept of dangerousness, then and only then will you actually be able to develop any kind of a tool which is which brings about just outcomes, right? So RA Duff tries to maybe work in this direction a bit. Another work that I would like to bring to your attention is in terms of Christopher Slobodan, who wrote a book titled Minding Justice, right? So Christopher Slobodan in this work, he argues that the decision to preventively detain a dangerous offender, it has to be governed by two criteria. The first is a psychological criteria, which pertains to the psychological trait which distinguishes dangerous people who need to be preventively detained from dangerous people who don't need to be preventively detained. You know, and this idea, and he also defines this idea of dangerousness by saying that that a person is a person is considered to be dangerous if he's impervious to the to criminal punishment itself. That is, he will be completely undeterred by criminal punishment itself. Secondly, he says that this must be followed up by a predictive criteria, which determines whether such dangerous offenders which will actually translate their desire to commit an offense into action, right? And such a decision regarding that predictive criteria itself has to be guided by a proportionality principle. That is, the degree of the danger for which for preventive detention should be proportionate to the degree of deprivation of liberty, and the consistency principle, that is, the degree of dangerousness which is required for preventive detention should be similar to the degree of dangerousness sufficient to authorize similar liberty deprivations in other situations as well, right? So what Christopher Slobodan is trying to do here is that, one, he's defining this concept of dangerousness, and then he's giving us a set of normative principles, right? That at the first stage you have to determine, if that person satisfies the psychological criteria, right? If he passes that stage, then we move on to the second stage of predictive criteria. And once he satisfies this stage, this satisfaction itself should be guided by two other principles: the proportionality principle and the consistency principle, right? So imagine if we try to apply this kind of a discourse in terms of the development of that AI tool itself, right? Imagine the implications for the same. Because what this is going to do is that this is going to imbibe principles from within the realm of criminal law itself in order to determine how that AI tool itself will be developed and how that AI tool will function. What kind of values will it actually imbibe? And in imbibing those values, how will it be able to get rid of biases? How will it be able to, how will it be able to compensate for principles or incorporate those principles of criminal law within its algorithm itself, right? Uh, another scholar, which deserves a pertinent mention, is Andrew Ashworth, who tied up with Lucia Zedner to produce a very seminal volume called Preventive Justice. So, in this book, Preventive Justice, Andrew Ashworth and Lucia Zedner, what they do is that they pitch this idea of the presumption of harmlessness as a antidote to the unprincipled application of the concept of dangerousness. They argue that even upon a conviction, a person does not forfeit such a presumption with respect to future offenses. Um, they say that a past harmful intention in respect of a single circumstance or a victim cannot simply be extended into the future. And this thing is that this presumption can be rebutted, according to Andrew Ashworth and Zedner, if and only if that person was convicted of a serious offense and can be classified as dangerous. A classification that requires a positive risk assessment. And according to Zedner and Ashworth, this risk assessment requires, firstly and most obviously, an assessment of the gravity of the harm in prospect. And secondly, it requires a separate assessment of the degree of probability that it will actually occur. So they formulated, in effect, two principles that can guide which levels are at least required for the imposition of the measures that involve preventive detention itself. They say that the grievous risk principle that requires that the prospective harm is then adjudged to be so serious as to justify that deprivation of liberty suffered by the individual detained, and that this principle itself should be combined with a high probability requirement, which is the second principle, which entails that the predicted occurrence of such is of such eminence and such high likelihood as to justify a detention in and of itself, right? So, coming to just conclude this entire presentation and tie this up together, the idea behind this entire presentation has been to maybe emphasize somewhere that the potential implications of an extension of a preventive rationale in criminal justice are, at the end of the day, very far-reaching. The deployment of preventive rationales inevitably results in an overextension and an over-application of our criminal justice system. It is as Marcus Dubber says, and the quote is on your screen. What is at stake is not merely the principledness of preventive justice, but the principledness of penal justice as a whole. The legitimation not just of the preventive state, but also of the penal state. This requirement that governments have today to act preemptively against violent offenses, this has completely diluted the boundary between this idea of crime control and this idea of security. Right? Legal responses to violent and serious offenses very often stretch the scope of criminal laws in very dramatic ways. And these overextensions have the potential of trampling civil liberties and promotion of a security state itself. And it has also been proffered in a different context that the basic features of the criminal justice system, when they're coupled with a goal of prevention, they tend to transform it into a preventive detention system in and of itself. And it is these implications which necessitate a very critical examination of the preventive rationales that underlie our criminal laws and criminal processes on a very principled basis, right? The basic idea here remains that, risk assessment and dangerousness, when they come to the point of decision making in the criminal justice system, in terms of the use of technology, in terms of the use of artificial intelligence, in terms of the use of algorithm, it is very important for us to ensure that such a use is then complemented and guided by a normative framework of a principled criminal law, right? And this brings us to the key takeaways that we have from our presentation today. Firstly, that the use of artificial intelligence has brought an increasing focus on this aspect of criminal law that has escaped the scholarly scrutiny that it deserves. And as AI comes to be increasingly applied in the realm of decision making in criminal law, it is very imperative that we identify and we rectify the problems which are associated with its application. And secondly, that the normative discourse on criminal law theory, it has the potential to guide the development of artificial intelligence tools in terms of risk and dangerousness assessment as well. And we must, explore these paradigms much further, right? So with this, I'll end my presentation and we can open the floor for Q&A, sir.
Yes, yes, sir. Yeah. Thank you very much. Participant, you can put your question in the chat box or you can raise your hand. There are a couple of questions I think already there in the chat box.
Okay. Sir, if you don't mind, I'll take them up one by one. There are three
Yeah,
questions that I can
sure,
see.
sure, sure. Over to
Right?
you.
Okay, so the first question is by Mr. Yogesh, and he's asking, is there any assessment tool used in the Indian judiciary for preparing case as defendant, lawyer, or prosecution? Which tool is advisable to prepare a case, if any? So this is something that I had mentioned during my presentation as well, that uh, this idea of this idea of risk assessment and dangerousness, even though this is very institutionalized in the Indian context through judicial decisions in terms of what factors have to be taken into account, for example, at the time of grant of bail or at the time of sentencing or at the time of deciding to give remission. um, there is these all of these decisions at the end of the day, they are informal in nature and they are very subjective in nature. So they will depend on the state government. So it will largely depend on the state government of the time, right, to decide if they want to grant remission in a particular case. It depends on the judge if they want to sentence a person to death or if they want to sentence that person to imprisonment for 10 years or life imprisonment. It depends on, again, the judge to decide whether they're going to be granting a bail. So we are very individual centric in that nature, right? And so I wouldn't be able to suggest to you any assessment tool which is used by the Indian judiciary, because there is no such tool that is being used by the Indian judiciary, right? Because it introduces that semblance of subjectivity. To some extent, we are also insulated from the problems that using these risk assessment tools bring with them, that I've highlighted in my presentation as well, right? I hope that satisfies your query, right? All right. The next is, sir, what is your take on Criminal Procedures Identification Act on criminal profiling, and on my take on surveillance to prevent crime, right? Okay, so if we try to think about it, the Criminal Procedure Identification Act of 2022, this was largely premised in the idea of on the in the idea of predictive. Lies in the realm of predictive policing, right? It doesn't apply this idea of risk assessment. It doesn't apply this idea of dangerousness as much as it applies the idea of us being able to identify a crime that might occur in the future in terms of in terms of who has committed that offense, right? Because we are looking at taking biological samples, we are looking at taking fingerprints, we're looking at taking their iris samples and all of these, right? So it allows for that, but again, it will not still be able to still be able to be used as a tool for the risk assessment and dangerousness, right? It doesn't provide you with that kind of the right data which is required for that purpose. An initiative which can actually do that in the Indian context is, CCTNS, the Crime and Criminal Tracking Network System, right? Because the kind of data that is collated by the NCRB for the and the state crime record bureaus, right? That is a data that is very pertinent for this purpose, because they're looking at not only what kind of crimes have happened, right? But they're also recording data with respect to who has been named in the FIR. They're also recording data with respect to who has been, charged for that particular offense. They're also recording data with respect to who has been convicted for which particular offense, and how many times have they been arrested, how many times have they been, how many times have they committed an offense, how many times have they re-offended as well. So that is the kind of data that can be used for the purpose of risk assessment itself. Your second question was with respect to surveillance to prevent crime. This is, in fact, one area where artificial intelligence is actually being applied in the Indian context, right? So you have, Bihar police, you have Nagpur police, you have initiatives by the Madras police, Chennai police, who have actually and even in the even by Delhi police, right? For example, this came up in a big way in terms of the Northeast Delhi riots, right? Where this became a question that you are profiling people on the basis of AI using CCTV footages, right? So surveillance can probably be used in terms of identification of criminals, but we have to remember that all of this comes with a caveat, and that caveat is that with respect to where we are with FRT, the facial recognition technology, we are currently only working with a very superficial, understanding of how these algorithms work, and also that we are, all whatever results are being turned up, they work on the principle of probability. So nobody can say with 100% surety that the person who's being identified is, for example, if you see me on a CCTV camera, um, that CCTV camera and that AI cannot recognize me with 100% certainty. So it's always about probability that it's 75% similar, that image is 75% similar, or that image is 80% similar, or that image is 10% similar. So, it's very much about, the decision with respect to who the police is arresting on the basis of that probability. So should we have some objective criteria with respect to how the police decides who to arrest, right? On the basis of what result that AI has generated. So we need to be very sure with respect to this, because this has the potential of curbing the liberties of the citizens to a very great extent. Then we have a question by Dr. Artik Kalnawat, who is asking, with India having common names and surnames for risk assessment in terms of actuarial systems, criminals or offender names and assessments may collide and further the process of risk of a different kind. Um, Okay, all right. So, I mean, there's a lot to unpack with respect to that question, right? First is with respect to in India, people having common names and surnames, right? So how these risk assessment tools actually work is not on the basis of, you know, whether that, you know, how many hits that system has with respect to that particular individual's name in the system, right? So we'll be very specifically looking at that individual. So how CCTNS, the Crime and Criminal Tracking Network System, collects that data is also with respect to determination of, for example, those in your CCTNS, you will also have your driving license number. You will also have their Aadhaar card, or you'll also have some address-based identifier, right? So you will be able to identify who that individual is in this sense, right? But the second part of the question, where you're talking about, for risk assessment in terms of actuarial systems, criminals or offender names and assessment may collide and may further the process of risk of a different kind. I would like to take a moment and then relate this question to the idea of bias, right? That this can perpetrate in the system, right? Because whatever researches have been done with respect to this, because these algorithms have only been applied in the context of US, the research has also been done only in the context of US or UK or New Zealand. We don't have these kinds of researchers in India because we don't have that kind of an application of such a software in the Indian context so far, right? But when you're talking about it in the context of US, you have this entire paradigm with respect to black versus white, black defendant versus a white defendant, and what is a black defendant's risk of reoffending and versus what is a white defendant's risk of reoffending. We can definitely apply this entire debate in the Indian context and take it as a warning, right? Because if we record it on the basis of the previous data that we have, right, you'll find that there is a very there is a good chance that whatever biases are present in the Indian criminal justice system at the moment, they will translate very directly into the bias that that risk assessment tool will also bring with it, right? Um, you know, right now at this point of time, 67% of our population, of our present population, is under trial, and almost the same number of them belong to SC, ST, or OBC categories, right, or minority communities, right? We see a very disproportionate number of individuals who belong to these communities being incarcerated, right? And if we end up putting this data as a for training our AI model, in order to see what is the risk of reoffending, it will quite obviously mean that any person who belongs to that SC category, ST category, or OBC category will, according to this algorithm, have a higher rate of incarceration, will have a higher rate of recidivism, and it's more likely to recommend such rate of recidivisms as well. So we need to be very careful when we're implementing this idea, right? So I've taken this a bit off track, but I've taken this opportunity as an opportunity where you're talking about certain surnames and names. So I've taken this as an opportunity to connect it with the larger issue that's in, that's problematic. Okay. So Pooja is asking me to conclude again, right? So in conclusion, my basic purpose with respect to that conclusion is that, today we have, this entire idea that preventive rationales and preventive criminal law, they're coming to, that they're coming to, act within our criminal justice system in a big way. And what this does is that this has the risk of, extending our criminal laws beyond whatever is, beyond their actual purpose, beyond their original purpose. And when you extend the boundaries of criminal law, the problem that emerges then is with respect to, the curbing of civil liberties, right? The ensuring, where the people themselves, their individual liberties, individual freedoms come under threat increasingly. Because criminal law itself, if you take a look at the nature of criminal law, it has that element of coercion and it has that element of stigma that is attached to it, right? So therefore, we need to be very careful in understanding what are the preventive rationales that underlie our criminal laws. What are the foundations of these preventive rationales? We need to understand this idea. What are the preventive rationales in risk assessment and dangerousness? And we need to come up with some kind of a normative framework with respect to dangerousness and risk assessment itself. And what this normative framework with respect to risk assessment and dangerousness will then do is that it will guide the development of AI tools. It will guide the development of actuarial tools that can help us very proactively understand what is the risk of, for example, reoffending, or what is the dangerousness of an individual itself, while at the same time balancing the concerns of the criminal justice system through the normative discourse. For example, by introducing this idea of presumption of innocence, right, into that algorithm itself. I gave you the examples of those three scholars for this reason, right? Because what those three scholars are doing is that they're coming up with a normative framework for risk assessment and dangerousness. And if we try to look at it, then these normative principles can actually guide the way we think about artificial intelligence in decision-making processes within the criminal justice system, right? Uh, Okay, all right. Then there's another question, which is on any key findings or interesting risk assessment on the SUPACE AI tool, like the SUPACE AI tool. I believe that you're referring to the AI tool that was recently launched for increasing code efficiencies, right? Um, Unfortunately, I mean, I don't think that this very directly pertains to our area, right? But what this will do is that this can definitely help the judge take very informed decisions with respect to that particular case. So right now what happens is that the judges, they primarily rely on whatever the submissions are being made by the defense advocates, whatever submissions are being made by the public prosecutors, right? And then they come to the conclusion, right? But what maybe this particular AI can do is to give them that information or some additional information in addition to the information that is given by public prosecutors or that is given by defense advocates, right? This can maybe also help bring on record certain exculpatory evidence that the public prosecutor may not have included. There's a very interesting, this can actually help in a lot of ways as well, because if you take a look at the Supreme Court judgment very recently in the case of Manoj versus State of Madhya Pradesh, right, where the Supreme Court said that there's a need for a mitigation specialist in deciding whether a death penalty should be awarded or not. So what is the role of this mitigation, expert? The role is to go and interview that individual and try to call out what are the mitigating factors that the court must take into consideration. So if this is a task that perhaps a AI tool can do, then it's well and good, right? Because I'm sure that such a tool can always incorporate certain psychometric tests within its ambit. And those psychometric tests can actually help us analyze what is the state of psychology of that individual. Maybe not at the time of the commission of the act, which might be relevant, but maybe later on as well, right? Or maybe at the very least, it can give us certain mitigating factors with respect to the same. So that's definitely there. It has some implications for sure. Okay. Then Dr. Varsha is asking, in the situation where AI is used in courts, whether the right to reasonable conclusions will be expected from judges. Or, okay, I think you mean reasoned conclusions and not reasonable conclusions. So I'm going to answer on this premise, right? So this is the big question, right? That the thing is that we can't let AI completely take over the decision-making process, right? At best, an AI is a tool, right? Something that can be used by a judge in order to come to a particular conclusion, right? It's not that AI tool itself is not going to determine that conclusion. At the end of the day, it must be the judge who decides whether or not to take into account what is whatever the AI is probably suggesting or recommending, right? So we should always have that discretion in mind. I think we should always come up with some kind of a system where we are giving that last discretion, that final discretion to the judge, right? And with respect to the exercise of this final discretion, I think, yes, it makes a lot of sense because we need to give reasoned orders. It's a principle of natural justice, speaking orders. We always need to give reasons for our decisions, right? Okay. Another question that we have is, what is your take on the criminal liability of AI? Will the study end ultimately on conferring legal personality on AI, or do you see that if there is a way in which we can hold AI or its owner or programmer or corporation criminally liable for its act. Okay, a very interesting question for sure. Like this is something that you know this is something that has been actually debated a lot. That wherever, for example, an artificially intelligent, maybe sometime in the future when we have Boston Mechanics integrating their robotics, Boston Robotics integrating their robotics with artificially intelligent, maybe maybe they end up causing the death of someone, maybe they end up harming someone. So the question is, who gets ultimately blamed for the same? Is it robots themselves, or is it the manufacturer who gets who is supposed to be made criminally liable? You know, at the end of the day, my answer remains the same as the earlier question, because AI is a tool, right? If it's a tool, a lot depends on who is using it, right? And so naturally, the liability must also pass on to who is, using that particular tool. In that sense, I would say, and artificial intelligence is no different than a gun, right? In the end, somebody has to pull that trigger, right? That trigger doesn't have, it's a figurative, idea, that ways. So, if it's a manufacturing defect, hold the criminal company liable. If it's the, uh, owner who has directed that AI to do something, then, it's the owner who's liable. I mean, so the idea of causation comes into play in a big way, in terms of criminal liability, right? Uh, okay. A follow-up question to this is, can this study or research take the path in which corporate criminal liability is fixed? Sure. Yes, very well. Like that's one area of criminal law where we actually need to focus on, especially in the Indian context, because corporate criminal liability in India, is at a very weak footing, right? It's only very recently that we've actually recognized that mens rea can be attributed, to a corporate, right? And that idea itself is too little too late, right? So therefore, yes, we should definitely focus on, this is a good area for research in terms of deciding or determining, where does this interface between AI and corporate criminal liability lie, right? Okay, all right. I think we're done with the questions then, sir.
Yes, yes, yes. I think it will take a few, so many questions were there, so I had to say no right now. But it will take half an hour more. So I request Sikhar Gupta to give a full word of thanks to Mr. Ankit. Over to you.
So, I, Shekhar Gupta, Assistant Professor for NFSU Delhi campus, on behalf of NFSU and Law Teachers India, express my heartfelt gratitude to Mr. Ankit Kaushik for providing this scrupulous understanding of the risk management approaches, the various tools used in risk management, and sir also evaluated the risk management tools and exposed our participants to the advantages and disadvantages of such systems. Thank you so much, sir, for this your thorough discussion on this topic, and also for generously taking the questions of our curious participants. Thank you so much, sir. I also express my thanks to the organizing team comprising our faculty members, Dr. Kalpesh Kumar and Gupta sir, Dr. Naptika Singh Nautiyal ma'am, Dr. Shraddha Rajput ma'am, as well as our dedicated student team for ensuring that these sessions run smoothly. With this, I declare the end of this session today. And participants, keep tuned in for more engaging sessions like this, and we may also have a session on the legal personality where we can discuss this in detail. So thank you, participants. Keep tuned in.
Thank you.
Thank you. Thank you.